one or two more questions. Why would you see the need to speculate when you were texting with Miss Merchant?
I think we did cover that one, Mr. Sadon. I think that exact question was already put to him. What would be the next one?
I'm trying to look. Let's go to 27. Defense Exhibit 27. Do you have that now, sir?
I do, sir.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Miss Merchant and a text response from you, correct?
But the text response was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now is, is the email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
As it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time.
Some objections, Mr. Abad?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, Defense Exhibit 27 is admitted. Anything else?
I don't know. Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Miss Willis existed before the contract in November 1st of 2021. That if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade had lied under oath. You know that, don't you?
I think that's going to call for an opinion on the credibility of another testifying witness, so I don't think that would be an appropriate question.
And that's all I have.
Thank you, Mr. Sadon. Mr. Stockton.
Just briefly, Judge.
We'll see.
Mr. Bradley, do I understand from your prior testimony that Ms. Merchant sent you a motion to review prior to her filing it?
Objection. Call some cumulative answers.
All right, I'm going to give him just a little bit. All right, Mr. Stockton. Maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you, in fact, review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Well, so you're referring to Exhibit 27, which, as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And you're aware, and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions we've covered ground. Let's get to that.
I'm trying to get that. She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
The actual motion that that was sent.
Yes.
I knew that she was going to file a motion, yes. I do not think that was the final draft, or it could have been that she was working on it, but yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
I'm going to object. All this is asked and answered in cumulative.
All right, noted. I think Mr. Stockton's getting to the next point, so why don't we just ask that one?
Is that correct?
Sure.
Did you?
We combine that with the next question, so we're not having to lay bit by bit every single
Mr.
time.
Bradley, you knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
No, I'd overrule that. Mr. Bradley?
No, so once again, I was excluded from the footnote of that motion, and my review of it, and I said, hey, you need to add me back to the footnote because I did have a contract and I did receive $74,000.
If I may help you out, let's talk just about that part of the motion that deals with the relationship between the District Attorney Willis and Mr. Wade. When you reviewed that, you knew that Miss Merchant.
I did not know that she was relying on me for any relying on me for any accuracy other than what was put in there. About the $74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Miss Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Miss Merchant.
If there was something patently speculative, you would have told Miss Merchant, wouldn't you?
I don't know what I would have told Miss Merchant. She asked me, was it accurate? We were discussing the $74,000 that was left out.
Again, if I may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as it relates to the relationship.
Repeat your question, I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with as it concerns the relationship because you did not see anything that was patently false, correct?
Objection. Asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there either, did you?
Asked and answered cumulative.
I know, sustained, Mr. Stockton.
I just want to ask you one more question. I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Miss Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the call that the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of it. So
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
no question, Joe.
Thank you, sir. Mr. McDougall.
As you come onto the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you.
That's what was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you answer that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougall. Mr. Rice.
Mr. Bradley, at least as of February 15th, when you first testified, you said you still considered yourself a...
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
And object as to past and answered and cumulative by all three of the previous.
Sure. We can put on that foundation. Why don't we combine it with the next question where you've got a new point to make?
Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
Did I lie to Miss?
That's a simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
Not that I recall. I don't recall. I mentioned earlier that I speculated on some things. I've testified to what I did know, so I can't recall whether or not no.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here. You're under oath.
Argumentative at this point, Your Honor. After relevant questions.
Mr. Bradley.
Final question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection asked and answered twice.
I don't think he's answered it yet.
I don't recall ever whether any of it was a lie or not.
Well,
This time, so
at the time you were communicating with Miss Merchant, you were still friends with Mr. Wade, correct?
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
correct.
And you knew that she was going to use that information to somehow benefit and file a motion and benefit her client, correct?
I did not know that. So I did not. Oh, I'm sorry.
So as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's relationship.
So at the time, no, I did not. I knew that Miss Merchant was gathering information. That is correct.
Okay. And did you lie to her when you told her that the relationship began before 2020.
I don't think we need to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true the only thing that has really changed, well, when you were speaking to Miss Merchant, whether by text or by telephone, you never said to her that I don't remember or that I'm speculating, correct?
I don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said, I don't remember?
Yeah, through the messages that I don't have all the messages in front of me, but no, I don't recall if I ever said I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating, no.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Gabe Banks, correct?
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we are fraternity brothers, and so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Have I told lies about friends? I could have, I don't know.
Do you tell lies about your friends about a case of national importance?
Objection as to
Overruled.
I could have, I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's the next
screen.
question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir. Mr. Gill.
Good afternoon, Mr. Radley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Radley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent to you. Remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent you. Do you remember
That was
reading?
sent on the 6th.
Excuse me. Do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
There wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney, in her office and the special prosecutor from further prosecuting the matter, right?
I'm going to object to speculation.
You knew that, didn't you?
Overruled.
Yes or no?
But if she said that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that.
Yes.
Because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right. Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do in argument. He said as a whole that he got the motion, and he's had his responses to his opinion of how he handled it. I don't see, again, this really being necessary to go through it line by line of what.
Well, a little indulgence, Your Honor. I'm not going to go. This isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
That's the problem in always ending in blast.
it very much is. And next time it has to, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
that was kind enough, and then the court said we had to go.
I need to draw straws next
There
time.
we go. I'll go with that.
All right.
Thank
Anything
you,
else?
Ron. That's all I have.
Okay. We had Mr. Couture potentially still on Zoom.
Yes, Your Honor, I have just a few questions.
All right. Could we add a spotlight to Mr. Couture? I'll let you know when we're able to proceed.
Judge, before it starts, can I take a 5-minute restroom?
Absolutely.
2 hours.
Yeah, we've been going 2 hours, so let's come back at 4 o'clock. I'll also note for the record that we received notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my question would be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just sit up.
And that wrapped up part 4. The judge went out on recess or lunch break, and that was Mr. Bradley's testimony to his best of his ability. He is not invoking attorney-client privilege anymore because the judge had him in chamber with his counsel, his lawyer, and determined that not everything that he was keeping and refusing to disclose was considered privileged attorney-client information. And so they put him back on the stand to testify to the best of his ability what he knew about the relationship between D.A. Fani Willis and attorney Nathan Wade. On that note, I'm over and out. I'll see you guys in the next one. Don't forget to hit the like bell and subscribe. This audio is being availed to us by 11 Alive News. They are one of the news teams that are right inside of the courtroom to bring us footage. Thank you for watching.